Usually an X-ray or an MRI is viewed as like the ultimate objective truth.
Right. It's just biology.
Exactly.
Yeah.
You slide into that magnetic tube, the machine scans your body, and you get a binary answer. You either have a broken bone, a torn ligament, or you just don't.
The images themselves don't lie.
Right. But what happens when the person reading those images, the professional translating those shadows into an actual diagnosis, is allegedly financially incentivized to see injuries that simply are not there?
Well, that's when things get complicated. Because then you're replacing the objective truth of a medical scan with a highly profitable fiction.
Which is terrifying.
It really is. It transforms the whole medical imaging process from a tool for healing into a potential engine for massive financial fraud. And proving that transformation in a court of law is, it's incredibly staggering in its complexity.
Which is exactly why we are taking you on this deep dive today.
Welcome.
We are so thrilled to have you with us because our mission today is to decode a fascinating brand new federal court order.
Brand new, just days ago.
Yeah, issued on March 20th, 2026 by Judge Natasha C. Merle in the Eastern District of New York. We're looking at a dense 28-page legal memorandum and order.
And this is in the case of Union Mutual Fire Insurance Company v. CitiMed Complete Medical Care.
Right. And we are going to use this document to explore exactly how a multi-million-dollar medical fraud scheme allegedly operates. Plus, pull back the curtain on the intense legal checkpoints a case like this has to survive just to make it to trial.
Yeah, this document is essentially a masterclass in procedural warfare. It's all the stuff that happens long before a jury ever even sees a piece of evidence.
Because at this stage, the court isn't deciding guilt or innocence, right?
Exactly. The judge is just acting as a gatekeeper. The defendants here filed a motion for judgment on the pleadings.
Which means what, in plain English?
It's a formal way of telling the judge, the plaintiff's accusations are too flawed or too vague or legally impossible, so please throw this entire lawsuit out right now.
Okay, so before we get into the legal arguments, we really have to establish the facts on the ground. We have an insurance company, Union Mutual, suing a medical clinic, CitiMed. What exactly are these defendants accused of doing?
So Union Mutual claims that CitiMed, which is a New York-based diagnostic imaging practice, and its owner, Dr. Regina Moshe, operated a years-long fraudulent scheme.
And how did this scheme allegedly work?
Well, the timeline involves patients who are often victims of, slip and falls, car crashes, construction accidents.
Sure, standard personal injury stuff.
Right. And they're sent by their primary referring doctors over to CitiMed for MRI and X-ray imaging.
Which, again, sounds totally standard. You get into a fender bender, your doctor wants to make sure your spine is okay, so they send you for a scan. Where does the alleged fraud actually begin?
The alleged fraud happens in the generation of the written medical reports. Union Mutual claims that after conducting the scans, CitiMed systematically fabricated the findings.
Wait, fabrication, like completely made up?
According to the complaint, yes. They allege the clinic would routinely diagnose severe injuries that simply did not exist on the actual film. Or, in other cases, they'd intentionally omit crucial findings.
Omit things? Like what?
Like normal aging. For example, if a patient had a spinal issue caused by just regular degenerative aging, the clinic would allegedly leave that detail out of the report.
Ah, I see. So the pain appears to be an acute injury caused strictly by the recent accident.
Exactly. It makes the accident look much, much worse.
Okay, to make this concrete, the court document gives us a really detailed look at a patient identified as claimant A. Tell us what allegedly happened there.
So claimant A slipped and fell on a sidewalk in September 2018. They sought treatment and about 8 months later were referred to CitiMed for a spinal MRI.
Okay.
The official signed report generated by CitiMed claimed the patient had suffered annular tears at 2 different locations in their spine.
And an annular tear is?
It's a specific, very painful tear in the tough exterior of a spinal disc.
Got it. But the insurance company didn't just blindly accept that piece of paper, did they?
No, they didn't. Union Mutual eventually hired their own independent radiology expert. And that expert didn't just read CitiMed's summary, they requested the raw data.
The actual images.
Right. They loaded up the original MRI DICOM files, went slice by slice through the digital imaging of claimant A's spine, looking specifically for those tears.
And what did they find?
Zero evidence. None. Absolutely no annular tears.
Wow.
What they did find was multi-level degenerative disc disease, just normal wear and tear, but CitiMed had entirely omitted that from their official report.
Okay, let's unpack this for a second. If I take my car to a mechanic after a minor crash, right?
Sure.
And the mechanic lies to my auto insurance company, saying the entire engine block cracked so they can bill for a massive repair.
Right.
That makes sense. The motive is obvious. They are lying directly to the payer to get a bigger check.
All right, the direct payout.
But here, the clinic is allegedly sending these exaggerated or fake reports back to the referring doctors too. Why trick the other doctors? What is the business advantage of lying to your own medical peers?
Well, the strategy here revolves around becoming the linchpin of a much larger personal injury ecosystem. The alleged goal isn't just to get paid for one isolated MRI.
And what is it?
The goal is to become the absolute go-to clinic for personal injury lawyers and doctors who specialize in accident cases.
Oh, I see.
Because when a patient gets into an accident, the referring doctors and the attorneys need documented medical proof of severe injuries.
To justify further expensive treatments like spinal surgery.
Exactly. Or to demand massive settlement payouts from the insurance companies.
Because a settlement for normal aging is $0. But a settlement for 2 accident-caused spinal tears is, what, potentially hundreds of thousands of dollars?
Precisely. If CitiMed builds a reputation as the clinic that consistently finds the severe injuries needed to fuel those lucrative lawsuits, they guarantee themselves an endless pipeline of patients.
The referring doctors just keep sending patients their way.
Because CitiMed provides the paperwork that keeps the entire financial wheel turning?
Wow. So if you are the clinic, and you are certainly caught with these seemingly fake reports, you don't just surrender, you look for a legal trapdoor.
Right.
And CitiMed's first instinct in this document isn't even to defend the medical reports. Their first instinct is to claim the federal court isn't allowed to judge them at all.
Yeah, in the legal world, before you can argue about who is right or who is wrong, you have to prove you are fighting in the correct arena.
Right, the jurisdiction.
Exactly. CitiMed tried to use a technicality to escape federal court. It's called a Rule 12b1 motion to dismiss for lack of subject matter jurisdiction.
Why do they care so much about which building the trial happens in, like federal versus state?
Well, federal courts often have stricter procedural rules. The judges move cases along aggressively, and they have incredibly broad discovery powers.
So defendants facing massive fraud allegations generally want to avoid federal court.
Usually, yes. Now, Union Mutual filed this case in federal court under something called diversity jurisdiction, which allows federal courts to hear cases between parties from different states.
But there's a catch, right?
There is. The amount in controversy, the actual money being fought over, must be strictly over $75,000.
Here's where it gets really interesting to me. I'm looking at the complaint, and Union Mutual explicitly alleges they've suffered over $3.3 million in damages from this scheme.
That's right.
So they're claiming $3.3 million, and the minimum threshold is only $75,000. They're fighting over a $75,000 minimum when the damages are in the millions. Is this just a desperate legal stall tactic by the clinic, or do they have a legitimate defense?
What's fascinating here is the highly technical angle CitiMed attempts to play. They actually don't dispute the $3.3 million total.
Wait, they don't.
No. Instead, they argue that Union Mutual never made any direct payments to CitiMed itself. The clinic claims the insurer only paid third parties.
Third parties like who?
Like the referring doctors who did subsequent treatments, or the hospitals that performed surgeries based on those MRI reports.
Ah.
So because of that separation, CitiMed argues the damages linking them directly to the insurance company are entirely speculative.
I see. And if the direct damages are speculative, they're saying the court can't guarantee that the $75,000 threshold has been crossed by CitiMed specifically.
Exactly.
But Judge Merle doesn't buy that argument for a second.
Not at all. The judge shuts it down by pointing to the actual physical evidence submitted with the complaint. Union Mutual was not vague about this.
Right, they had receipts.
They attached a specific exhibit listing 28 distinct claims, complete with exact dates of treatment. Most importantly, the complaint explicitly alleges that Union Mutual issued direct payments to the defendants via mail and electronic funds transfers.
And because this is just a motion to dismiss, the rules of the game require the judge to assume the plaintiff's factual allegations are true for now, right?
Yes. The legal standard applied here is called legal certainty. When a plaintiff states a dollar amount in their complaint, there is a strong legal presumption that the number is claimed in good faith.
So the defendant has to prove it's impossible.
Right. To win this argument, a defendant must prove that it is legally impossible, a mathematical certainty, that the plaintiff could recover the $75,000.
And because Union Mutual provided a detailed list of direct EFT and mail payments contributing to that $3.3 million total, the court easily confirmed it has the power to hear the case.
Exactly. Jurisdiction established.
Okay, so having failed to escape the federal arena, the clinic is forced to pivot. They survived the jurisdiction battle, so now they attack the accusation itself. They argue that the insurance company's lawsuit just wasn't specific enough.
Yes, and this brings us to a critical procedural hurdle known as Rule 9b of the Federal Rules of Civil Procedure.
Rule 9b.
Right. In a standard civil lawsuit, say a simple breach of contract, the plaintiff only needs to provide a short, plain statement of what happened. But fraud is a different beast entirely.
Because it's a much heavier accusation.
Exactly. Accusing a licensed medical professional of fraud is a severe charge that can destroy their career. Because of that risk, the law requires heightened pleading.
Meaning, you can't just walk into court and say, you defrauded me.
No, you must state the circumstances constituting the fraud with extreme particularity. You have to spell out the who, what, where, when, and exactly how the deception occurred.
And CitiMed's lawyers totally zeroed in on this. They point out that while Union Mutual gave incredible deep dive details on claimants A, B, and C, like the exact dates of the MRIs, the specific fake findings of annual retiers, they handled the rest of the cases differently.
Right, the bolt of the claims.
Yeah. For the other 25 claims, which they labeled claimants D through BB, the insurer just attached a spreadsheet list without writing out a multi-page narrative for every single patient.
And CitiMed argues that because the deep details only cover 3 people, the other 25 claims should be thrown out for lacking particularity.
Okay, so is this kind of like the legal equivalent of accusing a student of cheating by going to the principal and saying, oh, they cheat all the time?
Yes.
Versus saying, on Tuesday at 2 p.m., the student looked at a smuggled answer key for questions 1 through 3, and here is a list of 25 other test dates where they sat in the same seat and used the exact same method.
That analogy perfectly captures the judge's reasoning here.
So how specific does a lawsuit really have to be when a scheme involves dozens or hundreds of instances?
Well, a blanket statement of they cheat all the time would be immediately dismissed under Rule 9b. But providing a microscopic breakdown of the method used on Tuesday at 2 p.m. and then providing a specific ledger of the other dates, that satisfies the rule.
It's enough to go on.
Exactly. The ultimate goal of heightened pleading isn't to force the plaintiff to write a 1,000-page novel before discovery even begins. The goal is fair notice.
Fair notice for the defendants.
Right. The defendants need enough specific, granular detail to know exactly what alleged behavior they're defending against so they can pull their own records and actually prepare a defense.
And Judge Merle ruled that claimants A, B, and C serve as perfectly valid representative examples of the larger 28 claim scheme.
She did. They survived the Rule 9b challenge.
But the clinic doesn't stop at attacking the spreadsheet. They also attack the psychological element of fraud. The intent.
Right. The legal term for this intent is scienter. You have to prove the defendant knew they were lying and did it on purpose.
Which is hard to prove.
It is. CitiMed attempts to reframe the entire multi-million-dollar lawsuit as just a simple difference of medical opinion.
Oh, that's clever.
Right. They argue that reading an MRI is a complex, nuanced art. 2 highly trained doctors can look at the exact same shadowy image of a spinal column and disagree on whether a tiny gray line is a tear or just an artifact on the film.
So they're saying a disagreement between doctors is just the practice of medicine, not a fraudulent conspiracy.
Exactly.
But how does an insurance company prove, especially at this early stage, that the clinic didn't just make an honest mistake in reading a blurry scan?
Well, at the pleading stage, the plaintiff doesn't need a taped confession. They just must allege facts that give rise to a strong inference of fraudulent intent.
Strong inference, okay?
And Judge Merle ruled that Union Mutual easily met this bar. The complaint doesn't just allege a minor disagreement over subtle nuances.
Right, it alleges the intentional, systematic invention of severe injuries that are demonstrably absent from the raw data.
Exactly, coupled with the intentional deletion of pre-existing conditions.
Right.
When a clinic routinely imagines non-existent injuries that perfectly align with maximizing their own personal financial profit, the court recognizes that as a strong inference of scienter, not a harmless medical oops.
It's a difference between 2 doctors debating the exact severity of a visible fracture versus 1 doctor claiming the leg is shattered in 3 places when the bone is completely intact.
Exactly the distinction the judge is making. Obviously, when this case reaches an actual trial, CitiMed will have the chance to put their own experts on the stand.
And if they prove it genuinely was just a subjective difference of opinion.
Then the fraud claim will fail. But today, Based on the detailed allegations of a profit-driven fabrication machine, the case moves forward.
Okay, so the lies are documented with specificity, and the intent to defraud is properly alleged. But that brings us to the next mandatory element of a fraud claim.
Yeah.
Did the victim actually fall for the lie?
And was it reasonable for them to be fooled?
Right.
This is the reliance element. You cannot sue someone for fraud if you never believed their lie or if you didn't act on it to your own detriment.
Makes sense.
So CitiMed brings out what is known as the conduit defense. They argue that they never sent these allegedly fake MRI reports directly to the insurance company.
But they sent them to the referring doctors, right? And the patients and the personal injury lawyers.
Exactly. Therefore, CitiMed argues Union Mutual couldn't have relied on a misrepresentation made directly to them because they weren't in the room when the lie was told.
First of all, the judge points out a factual flaw in that defense.
She does. The judge notes that the complaint explicitly states CitiMed did intentionally transmit reports directly to the insurer to get paid.
Okay, so that kind of blows up the defense right there.
It does, but the judge goes a step further to address the reality of how these medical networks operate. She cites a recent precedent from another case in the exact same district, the stand-up MRI case.
And what did that establish?
It established that a fraudster cannot escape liability just by using a middleman.
Meaning, like, if I hand a forged check to my friend and tell my friend to go cash it at your bank, I can't claim innocence just because I didn't walk into the lobby myself.
Correct. The legal concept is that the third party, the referring doctor or the lawyer, acts as a mere conduit for the lie. Right. As long as CitiMed intended for those fabricated reports to eventually land on the desk of the insurance company to trigger a payment, that indirect reliance fully supports a fraud claim.
Wow. So what does this all mean? Because that brings us to a defense that genuinely surprised me when I read this order, is the MRI film defense. CitiMed actually argues that the insurance company had access to the underlying raw MRI data. The clinic's lawyers are essentially telling the judge, if our written reports were so blatantly fake, the insurance company should have just looked at the digital images themselves and caught the lie.
Blaming the victim.
They are. They're blaming the victim for believing the paperwork instead of auditing the raw data. Wait, if the insurance company literally has the original MRI film in their hands, isn't it kind of on them if they don't look at it? Why does the law let them off the hook for not double-checking the doctor's math?
If we connect this to the bigger picture, the sheer mechanics of the American healthcare system explain why the court rejected this defense immediately. Think about the volume of claims an insurance company processes every single day.
It's massive.
Millions of diagnostic codes, billing forms, and medical reports flow through their servers. Modern insurance relies heavily on auto-adjudication.
Right, software doing the work.
Exactly. Software that reads the codes and pays the bills automatically, based on the assumption that a licensed, heavily regulated medical professional is telling the truth.
The system is built for speed and baseline trust.
The alternative is administrative collapse. If the law required insurance companies to hire an army of independent radiologist experts to manually review the raw DICOM files of every single routine medical scan before paying a simple diagnostic bill.
The system would grind to an absolute halt.
Absolutely. It takes time and serious money to have an expert go slice by slice through a spinal MRI. Claims processing would take years. The administrative costs passed down to consumers would be astronomical.
So the law protects them.
Yes. The law clearly states that insurers are legally entitled to rely on facially valid medical claims. If a licensed doctor submits a signed report that looks legitimate on its face, the insurer is allowed to believe it.
It makes sense. You can't engineer a functional healthcare system that operates under the legal assumption that every single doctor is actively committing felonies.
Right.
But while Judge Merle allows this massive core fraud claim to proceed to discovery, she doesn't hand the insurance company a flawless victory. She actually trims the fat off the lawsuit.
Yeah, in high-stakes civil litigation, lawyers rarely file a complaint with just one single cause of action. They throw multiple legal theories at the wall.
Just to see what sticks.
Exactly. So in addition to fraud, Union Mutual also sued for unjust enrichment and asked for a declaratory judgment. Judge Merle systematically dismisses both of these secondary claims.
But wait, if the clinic allegedly defrauded the insurer out of millions of dollars, weren't they inherently unjustly enriched by keeping that money?
They absolutely were enriched. But under New York law, unjust enrichment is not a catch-all claim you can just staple onto the end of a lawsuit.
Oh, really?
No, it is a very specific, equitable remedy. It's designed for unusual situations where no traditional legal wrong, like a contract breach or a tort, occurred, but equity and good conscience demand that money be returned.
I see.
Judge Merle points out that Union Mutual's unjust enrichment claim is based on the exact same factual allegations as the fraud claim.
They both rely entirely on the existence of the fabricated medical reports.
Yes. Furthermore, the money sought for unjust enrichment is just a smaller subset of the exact same $3.3 million sought for the fraud.
So it's like charging someone with stealing a car and simultaneously suing them for unjustly enriching themselves with a free car. The judge is saying you cannot double dip on the exact same bad behavior.
They are legally categorized as duplicative. Think about how a jury would look at this. There is no plausible alternate universe where a jury listens to the evidence, decides that CitiMed did not commit fraud and never lied on any reports, but somehow still decides that equity demands the clinic return millions of dollars.
Right. If there's no fraud, there's no unjust enrichment.
Exactly. The core theory of deception must be proven for either claim to work. Because the fraud claim adequately covers the dispute, the redundant unjust enrichment claim is thrown out.
And the declaratory judgment.
The judge applies the exact same logic there, keeping the entire litigation streamlined and laser-focused on the primary issue of fraud.
Which brings us to the ultimate conclusion of this 28-page order. The clinic's attempts to dismiss the case have failed.
The core multi-million-dollar fraud claim survives.
The legal gate has been opened, and the case is now being handed over to Chief Magistrate Judge Vera M. Scanlon for pretrial supervision in the discovery phase.
This is the moment the theoretical legal arguments end, and the hunt for hard evidence really begins. Emails will be subpoenaed, internal clinic communications will be exposed.
Billing ledgers will be analyzed.
And those raw MRI files will be heavily, heavily scrutinized.
And this is exactly why you, the listener, should care deeply about a procedural ruling in a Brooklyn federal court. It is incredibly easy to view a lawsuit between a massive insurance company and a corporate medical clinic as a victimless fight over spreadsheets.
But it's not.
No. These specific types of alleged schemes, billing for phantom injuries, padding reports to spark sham personal injury lawsuits, performing medically unnecessary spinal injections or surgeries based on fake data, they don't just hurt the bottom line of the insurance carrier.
Right. They are a massive driving reason why general liability and auto insurance premiums skyrocket year after year for everyday people.
The financial cost of every fabricated annular tear is eventually passed down to the public in the form of higher monthly premiums. It functions as a hidden systemic tax on every single person who drives a car, owns a business, or even just walks on a city sidewalk.
This raises an important question, though, and it is something deeply provocative to consider as we watch this case move into discovery. Uncovering this specific alleged scheme from 2018 required a manual, highly labor-intensive process. It required an independent medical expert to sit down, pull up old digital files, and manually review spinal imagery frame by frame to spot the phantom injuries.
Which takes a ton of time and money.
Exactly. Knowing how slow and expensive that manual catch is, we have to wonder how much undetected, fabricated medical fraud is sitting quietly in filing cabinets and on hospital servers across the country right now.
Given the sheer volume of daily claims, it is probably a staggering amount.
And what happens in the very near future? What happens when insurance companies stop relying on isolated manual expert reviews and instead unleash artificial intelligence to retroactively cross-check millions of written medical reports against the actual raw imaging data in a matter of seconds?
Wow. When the technology catches up to the volume of the paperwork, that completely changes the game.
It really does.
Suddenly, the objective truth of the X-ray machine gets restored, and a whole lot of profitable fictions might be dragged into the light. It is going to be a fiercely contested space to watch.
Absolutely.
Thank you so much for joining us on this deep dive. We will be keeping a close eye on Judge Scanlon's docket to see exactly what discovery uncovers in the CitiMed case. Until next time.